Welcome to YouTube class. We shall start with a new chapter today. That is, I think, just a minute. So we'll start this one. Just a minute. So we shall deal with center-state relationship. Center-state relationship in India. The chapter name. Center-state relationship. We will discuss center-state relationship, a very important chapter in Indian polity. Center-state relationship is a very vital aspect of federal country, quasi-federal setup in India. It is essential for a better coordination and cooperation between the center and state. Otherwise, it would jeopardize the system. It would endanger the federal relationship and may lead to disintegration and other aspects. So, for the unity and integrity of the country, we need an effective center-state relations in India and also interstate relations. So, what is the need for a center-state relationship? And with regards to the federal country, with regards to federal country or federal setup, under the federal setup that we have, that India has, powers are divided between the center and states. But there the power is related to legislative power and your executive power and with regards to financial powers. So these powers are divided, not judicial powers, because we have an integrated judicial system to enforce the central as well as state laws. But these powers are divided. Although powers are divided, maximum coordination and cooperation between the central and state is essential for a steady maximum cooperation and coordination, or maximum cooperation and coordination between the center and state is essential for effective, or you can say effective and effective operation of the federal arrangement. Is that clear? So maximum cooperation is essential. Otherwise, it will lead to disintegration and disunity among the people, and it will lead to domination of regional forces, and it may jeopardize the unity and integrity of the country. So for the sustenance of a federal structure, for the sustenance and strength of the federal structure, we need an effective coordination and cooperation between the center and states. So for sustenance, you can write, for sustenance and strength of our quasi-federal setup, or quasi-federal setup, the Constitution must be supportive of a kind of cordial and durable relationship between them, between the center and states. For this purpose, with a view to providing realizing such relationship The Constitution contains extensive provisions for regulating various dimensions of the relations between the center and states. The center-state relationship can be analyzed under three heads: legislative relationship, administrative relationship, administrative relations, and financial relations. So we can broadly study center-state relation in India. In this manner, the Constitution provides for the Constitution provides for the three types of relationship in the manner of legislative, administrative and financial relation. We will discuss them broadly. What are the major aspects of each relationship? First of all, we shall deal with legislative relationship. Legislative relations means law-making relationship. As you know, the 7th schedule deals with the division of legislative powers. There are three lists like union list, state list and concurrent list. The parliament is authorized to legislate on the subjects mentioned in the three list, in the union list, and the states are authorized to legislate on the state list, and both the center and states deal with the concurrent list. But apart from this regular division, there is much overlapping, or there is much interpretation or most impact dimension of this relationship is not as clear as it seems, because we have a typical federation, a quasi-federal, for strengthening the unity and integrity and maintaining the unity in diversity. We have done a lot of changes, lot of amendments in this matter. So, Part XI, Article 245 to 255 deals with legislative relations between the center and states. Apart from these, there are other provisions in the Constitution also which deal with the legislative relationship. There is also territorial limit defined in case of legislative power, but the Constitution provides for parliamentary legislation in the state list for 5. So as other federal constitution, the legislative powers of the center and states are determined with respect to both territory and subjects. Means how far the center can legislate, or the central law has an effect on the territory of India, but the state law has effect on the territory of the state only. The central law can have also, laws can have also effect or application in a part of the states, in part of India or parts of India. So state also can make legislation for a part or parts of the state. So the state law cannot exceed beyond the territorial limit of the state. So also the parliament can legislate on any matter mentioned in the union list which may have the application across the country. It has also extraterritorial jurisdictions. But in case of state, it does not have extraterritorial jurisdiction. Its laws are confined within. So there are the union government, the union legislature has absolute authority over the union list and overriding power over the concurrent list. So what is this? Parliament can make law on any matter mentioned in the union list. The state legislature are not authorized to make any law on the subject mentioned in the union list. That is a supreme domain of union government. And also, in case of concurrent list, where both center and state can legislate, the center or the union legislature has overriding power. In case there is a conflict between the center and states on any matter mentioned in the concurrent list, the will of the center prevails over the state. So although the state legislatures are authorized to legislate on the matters mentioned in the concurrent list, the ultimate power lies in the center, because if there is a conflict between the central law and state law on any matter related to concurrent list, then the central law will prevail. Therefore, we say that it has an overriding power over the concurrent list. And also the residuary power of legislation. Residuary power of legislation vested in the center. The legislative power of the residuary power is vested. However, the Constitution provides for parliamentary legislation in the state field under 5 extraordinary situations, as well as there are central control over state legislations. So the center-state legislative relation can be broadly studied under the 4 heads. Okay, so that is the parliamentary. There is constitutional provision under certain okay. So center state legislative can be broadly discussed under following premises. Number one, territorial extent of center and state relations, center state legislation, sorry. Then number two, distribution of parliamentary legislation and center's control over okay. Okay, so these are the four aspects. Territorial extent of central and state legislation means that I was telling you the effect of a central law can be applicable to parts of the state, parts of India, a part of India, or the whole of the geographical territory of India. But in case of state legislation, it is applicable only state area, but we will see that. Distribution of legislative subject under article that is schedule 7, the powers of legislation has been divided. Okay, first we shall discuss the territorial extent. Territorial extent of central and state legislation. The Constitution defines the territorial limit of the central and state law in various ways. So we shall discuss that. As I told you, number 1, the Parliament can legislate for the whole or any part of the territory. And as you know, territory of India includes the states, the union territories and the acquired territories. So it can make legislation not only for the state and the union territories, but also for any territory that is acquired by India from time to time. The states do not. Number 2, the state legislature can make laws for the whole or any part of the state. The laws made by the state legislature are not applicable beyond the geographical limit of the state. Okay, are not applicable outside the state except when there is a sufficient nexus between the state and the subject. So that is exceptional cases, but usually the laws enacted by the state legislature can be applicable or are applicable within the territorial limit of the state. Number 3, Parliament can make extraterritorial jurisdictions. Extraterritorial legislation. Parliament can make law for Indians residing outside the country and for the regulation of their property in any part of the world. It can make laws for the NRIs, for the others who are there. So it is called extraterritorial legislation, and it the parliament which is only authorized. So that is called the territorial limit of the central law. However, there are certain restrictions imposed by the on the legislative powers of the center or of the parliament. So what are the restrictions? Restriction is that president can make legislations for peace, progress and good governance of union territories, such as Andaman Nicobar Island, Lakshadweep, Dadra Nagar Haveli, and Daman Diu, Ladakh, and he can also make legislation for Puducherry when the state the legislature of the union territory is not in session. And such legislation will have the same effect of law. Will have the same effect of law. And it can declare also any law, parliamentary laws. It can also declare any parliamentary law or repeal. It may repeal or amend any parliamentary law for this purpose. And I told you that President can also make legislation for Puducherry if the legislative assembly of the union territory is not in session. So that is a restriction on the absolute power of the legislative power of the state over the territory of India. Number two restrictions. The governor of a state is authorized governor of a state is authorized to direct that an act of parliament does not apply to a scheduled area in the state or apply with specified modifications. Number 3, the governor of Assam may direct that an act of parliament is not applicable to tribal areas. That is autonomous district council, autonomous district in the state, or apply with modifications. The president has similar power. President has similar power with respect to tribal areas in Meghalaya, Tripura, so these are also restrictions on the powers of the governor. Okay? So although Parliament has nearly absolute authority over the legislative authority over the union list and has absolute authority to make laws with regards to the territory of India. But these are the factors which limit the territorial limit or territorial sovereignty or territorial application of the parliamentary legislation. Okay? So we have discussed the first point, territorial extent of the center and states. Next is the distribution of legislative subjects. Distribution of legislative subjects. With regards to the distribution of legislative subject, the seventh schedule contains threefold division, like the union list, list 1 and the list 2, the state list, and list 3, the concurrent list in the seventh schedule. I told you that Parliament has sovereign authority over the union list mentioned in the union list, and state has, in the normal circumstances, has a complete power over the state subjects, and there are also concurrent list. Okay. So, the Parliament with respect to any matter mentioned in the union list, which is at present contains 98 subjects as mentioned, and subjects like defense, foreign affairs, currency, banking, insurance, atomic energy, census, transport and communication also. Communication and currency are important domains of central legislation. So subjects like defense, currency, banking, insurance, foreign affairs, interstate trade and commerce, census, communication, audit, so there are a great number of important subjects mentioned in the union list where the parliament is the authority to make legislation, and no authority is there to make legislation on these subjects. Likewise, the state list, the state legislature have exclusive authority to make law or list 2. List 2. There are 59 subjects, which was earlier 66 subjects. At present, subjects like public order, police, public health, sanitation, agriculture, local government, fisheries, theatres, gambling, markets. So there are a number of subjects which are there. These are the exclusive jurisdiction divided. List 1, list 2. Next is number 3. Both Parliament The 42nd Amendment Act 1976 also transferred 5 subjects: education, forest, weight and measure, protection of wildlife, animals and birds, administration of justice. Administration of justice, constitution and organization of all courts except the Supreme Court and High Court. So the concurrent list is a common list where the state and both the center and parliament, the states have the power to make legislation. Okay, so as I told you, once there is a conflict, when there is a conflict between the central and the state law, over the concurrent list, the former prevails but it is clear that matters of national importance like defense, currency, foreign affairs, census are put in the list 1, which require uniformity of legislation nationwide. Matters of regional importance and the matters in which permit diversity of interest are specified in the state list, and the matters on which the uniformity of legislation is desirable but not essential, and they have a common application or common interest. They are subjects of common interest of the central states. Then it is mentioned in the state concurrent list. In a typical federation like US and Australia, there is a federal government. The powers of the federal government are enumerated in the constitutions, and the rest of the powers are left to the states. So there is no clear-cut division in American system. There is only the federal subjects are kept aside, and all other powers are left to the state's discretion. But in India, it is not happening. Okay? But in India, there is two divisions, basically 3 divisions. One is federal, provincial, and the residuary powers are vested in the center. So unlike a and the residuary powers are vested in the So in case there is a overlap or there is a conflict between the central law and the state law on a subject mentioned in the concurrent list, the central law prevails. But if the state law has been reserved for the consideration of the president and has received his assent, then the state law prevails in the state, but it would still be competent for the parliament to override such a law by subsequently making a law on the matter. Okay, so these are the current distribution of legislative subjects. As you have seen, so we are not a classical federation, we are a quasi-federal, so our division pattern is not the same as the USA, where there is only two divisions. One is the subjects mentioned for the federal government, and the rest of the power are not mentioned. It is left to the state to decide what would be their powers. But India does not provide this type of division, rather it provides a quasi-federal system, an integrated system, where the powers are no doubt divided between the central and state, but there are certain aspects which makes the Supreme Court or makes the judiciary superior. Okay. So that is the things. And in case of overlapping, I told you, in case of overlapping, the formula will prevail, but exception is that if the bill has received the assent of the president, then it will prevail over the central law. So that is number 2. Now we shall come to number 3. Parliamentary there are certain circumstances the above distribution of legislative power, the above distribution of legislative power, that the center can make law on the union list and state can make law on the state list, and both center and state can make law on the subjects mentioned in the concurrent list. That is true. But the above pattern of distribution of legislation between the central states each okay. So the above distribution, as we have mentioned, they are very good, or they are to be maintained in normal times. But in certain exceptional circumstances, the above mentioned scheme of distribution is altered to a great extent. It changed to a great extent. It is either modified or suspended. In other words, the Constitution empowers the Parliament to make laws on any matter enumerated in the state list under the following extraordinary circumstances. So that is the text. The distribution functions or runs well in normal times, but in abnormal times or exceptional times, the scheme of distribution undergoes substantial changes. Okay. So next is, where are the fields? Fields. Okay. Fields of. Number one, when Rajya Sabha passes a resolution under Article 249 that it is expedient to make legislation on the state subject, as a benefit of the that is under Article 249. So Article 249 provides or authorizes the the Rajya Sabha to issue or move a resolution for law making. If it feels that it is expedient to make legislation on the state subject for the larger benefit of the states concerned. So that is Article 259. Then number 3, during a national emergency. During national emergency also, Parliament can legislate on the state subject during national emergency if it becomes expedient in the larger interest of the state or states. So national emergency, during the time the state or the entire country is in risk of losing its identity, or it may lead to certain circumstances which is unavoidable. Hence, Parliament assumes all the powers of lawmaking, disallowing the state to go for any new law. That we what call merge, or being during the national emergency under Article 240, 250. So that is there. When Rajya Sabha passes a resolution during national emergency, so when there is a national emergency, the state legislature is not suspended, but it appears to the Parliament to make legislation which will be applicable across the country, and that subject is mentioned in the state list, then it will be made by the Parliament, not the state legislature. So the legislative power of the state legislature temporarily snatched away temporarily allotted to Parliament during this time. That is also a point to remember during a national emergency, Article 250. Number 3. When states Article 252, when states make request, okay, okay. So when states make request, when state means more than one state, not one state only, more than one state make a request to the Parliament under Article 50, that it is essential to make a common legislation which will be applicable to both center and states. So that is, state makes no request. Okay, number 4. international relations and so these are the okay. So those you can see the various parameters of center-state relations, isn't it? So there are 4 dimensions where the state can make laws. And that is, you can see okay, just a minute. Okay. So these are the 4 areas where the center and state works together, and that is called to implement international treaties and agreements, to that is the things central's control over the judicial discuss. Center's control over the executive. So you can understand better that when Parliament can legislate on the state subject, there are 4 circumstances: when Rajya Sabha passes a resolution, when it is expedient, when during national emergency, when states make request, and to implement international treaties and agreements. But only the 2 states, a law to enacted applies only to those states which have passed the resolution. However, any other state may adopt it ordered by passing a resolution. Such a law can be amended or repealed by Parliament and not by the legislature of the concerned states. The effect of passing of resolution under the above provision is the Parliament become entitled to legislate with respect to matters for which it has no power to make. Okay. So these are the things of the center-state relations. And another aspect also I have not added. President's rule. During President's rule also. That might be 251. Article 251. Okay. 252, अच्छा, when the states make request, अच्छा. 251, okay, number 5, during the imposition of imposition of president's rule. So these are you can see these are the 5 areas where the center can make law. Center can legislate. Okay. Central's control over state legislation. Apart from the above, the Parliament's power to legislate directly on the state subject under the exceptional situation, the Constitution empowers the centre to exercise control over the state legislative nature in the following year. Okay. So, for example, the governor can reserve certain types of bills passed by the president, passed by the state legislature. The president has absolute veto with regards to state bill. Bills that contain matters in enumerated list in state list can be amended in the state legislature only with the okay. So these are the governor's legislation, and certain can be introduced in state legislation only with the previous sanction of the president. For example, bills imposing restriction on freedom of trade and commerce. The center can direct state to reserve money bills and other financial bills passed by state legislature for the president's rule during financial emergency. So central control over can be broadly discussed in 3 parameters. Apart from the parliamentary legislation, apart from the parliamentary legislation on state list, in exceptional circumstances, however, Constitution also contains circumstances. The Constitution also contains provision for central legislation. You can write central control over the state there. Governor can reserve a state bill. This is, governor can reserve a state bill for the consideration of the president. President has the absolute veto. Certain bills related to the state list may lead to require prior certain bills require the state approval of the president before ଆଜ୍ଞା ହଁ ସ୍କୁଲ ବସ୍ କେଜାଣି ମୁଁ କହିପାରୁନି କ'ଣ କରୁଛି ସେ ତ କାହିଁ ମେସେଜ ଦେଇନାହାନ୍ତି ତାହେଲେ ଦେଇନାହାନ୍ତି ନହେଲେ ଦେଖିବା ରାତିରେ ପଚାରିବାକୁ ନହେଲେ ମୁଁ କହିବି ପହଞ୍ଚିଲେ ହେଲା ନହେଲେ ଆମେ ନେଇଯିବା ହଁ କେଉଁଟା ହଁ ହଁ ହଉ ଦେଖିବା କ'ଣ କଥା ଅଛି certain bills related to state list may require prior approval of the president before its introduction in the state legislature. So that is Governor's Reserve Power Bill Article 200, and it is certain bills related to can be reserved for the president for reason if it is related, for example, if any bill restricting imposing restrictions on the freedom of trade and commerce, so the bill will be reserved for the president. And number 3, the money bills and finance bills passed by state legislature are reserved for the consideration of the president during financial emergency. So from the above it is clear that the Constitution has made the center superior to the states in almost all matters. That is called federal supremacy, and the famous Interstate Relation Commission, Sarkaria Commission, was of the view that federal supremacy is the rule of federal supremacy is a technique to avoid absurdity, resolve and conflict, and ensure harmony between union and state laws. If this principle of union supremacy is excluded, it is not difficult to imagine its deleterious results. There will be every possibility of our two-tier political system being stultified by interference, strife, legal chaos, confusion caused by a host of conflicting laws, most to the bewilderment of the common citizens. So, Sarkaria Commission favored federal supremacy because it is essential in this regard, as it was said, that the rule of federal supremacy is a technique to avoid absurdity, resolve conflict and ensure harmony between the union and state laws. If this principle of union supremacy is excluded, it is not difficult to imagine its deleterious results. There will be every possibility of our two-tier political system being stultified by interference, strife, legal chaos and confusion caused by a host of conflicting laws, much to the bewilderment of the common man. Integrated legislative policy and uniformity on the basic issues of common union state concern will be timid. The federal principle of unity and diversity will be very much a casualty. This rule of federal supremacy therefore is indispensable for the successful functioning of the federal system. The central has adequate control over the state list, as you have seen. So that means we can say that there is federal supremacy. And it is federal supremacy and it is indispensable. It's indispensable for successful functioning of the federal system. So, as Sarkariya Commission was of the view that it is essential to have one is superior. We have to be content with the federal supremacy because it is essential in the larger interest of the nation and in general and the people in particular. So there should be, and it is the duty of the lawmakers to maintain such supremacy in right proportion. Okay. So we have discussed the legislative relations between the central and states, and there is, as we have seen, there are in case of legislative relations, we have discussed various aspects like the territorial extent and distribution of legislative subjects and your parliamentary legislation in the state list, and also the center's control over the state legislations. In many ways, the state is being imposed as a subordinate to the centers, but it is essential. In the next class, we shall be discussing the administrative relation between the center and state. Administrative relations between center and state, next class. So I hope you people are getting some points here. Your points are getting some valuable tips for your writing papers. And center-state relation is an important aspect of our political paper 3. So this is the things. In the next class we shall be discussing okay. So thank you very much for being with us, We shall be back with your next chapter in the next segment of this class. Due time. Okay. So thank you very much to all of you. Have a good day.